Hello, wonderful people. Welcome back to this wonderful channel where we bring you back-to-back updates and information as the hot. If this is your first time of joining us on this channel, please go ahead and subscribe to our channel and all our social media handles. As the Almighty Chukwu man go carry blessing, come bring them for your house. Yeah, make we go for the business where we say, now carry us, come here. The DSS has opened up on why they oppose Nnamdi Kanu'S request for access to medical records. And as they brought out this the reason, Mazi Ozekome-san and his team has acted wisely. Of course, I will be bringing to you what Mazi Ozekome and his team did to counter what the DSS people are doing. Of course, ndị Igbo nwere gịnị, Igbo nwere ife, ndị Igbo ha nwere ife, watago. So, Miliadeshi, make we go down and see the hot. Abuja, the Department of State Service, DSS, has asked the Federal High Court sitting in Abuja to dismiss an application the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, filed to be granted access to his medical records. Kanu, in the suit he filed through his team of lawyers led by Professor Mike Ozekome-san, equally applied for an order of mandamus to compel the security agency to allow him to have unhindered access to his private physicians. However, when the matter came up for hearing on Tuesday, counsel to the DSS, Mr. A.M. Nnamdi, challenged the jurisdiction of the court to grant the request. Nnamdi told the court that the security agency had earlier filed both a preliminary objection and a counter affidavit to query the legal competence of Kanu's suit, insisting that Kanu has been receiving adequate medical attention in custody. The counsel to the DSS said he attached a feeding schedule that reflected the IPOB leader's demand for his choice of food. The DSS lawyer further attached an exhibit he said would show the court that the detained applicant was dutifully and clinically on his routine medication. We therefore urge the Honorable Court to dismiss the suit in the interest of justice and national security, Nnamdi added. Meanwhile, arguing the suit before the court, Professor Mike Ozekome-san told the court that the health of his client has deteriorated badly, accusing the DSS of refusing to allow him to get an independent medical examination. He told the court that a special doctor that was engaged by the security agency had warned that IPOB leader Mazi Nnamdi Kanu could die if he was not allowed to have access to a quality health care. All we are saying is, let this young man not die. They told us that they took his medical report to South Africa, but to date, we have not seen anything. Now they are talking about conducting ear surgery on him. The Supreme Court has repeatedly said that a man should be alive to be able to stand trial. This case has taken international coloration, and this court can save this country the opprobrium by ordering them to release his medical records. We have equally attached certified true copy of the judgment of a high court in Umuahia, which awarded 500 million naira damages for the extraordinary rendition of the applicant from Kenya. We humbly seek, my Lord, intervention in this matter. We are seeking solace for this young man who has been beaten blue and black with no one to stand up for him apart from this court. His doctor has gone there 2 times, but they refuse him entry. But here they are asking for release from the court when they have not obeyed a subsisting order of this same court. They cannot come before this temple of justice with soiled hand to seek equitable remedy. Moreover, my learned friend is missing the entire point. We are not here on the issue of whether they are feeding him or not. All we are saying is, let the treatment they claim that he is receiving be subjected to a review by an independent physician of his choice, Ozekome-san added. After she had listened to both sides, Justice Bing Tanyako adjourned the matter till July 20th for judgment. Specifically, Kanu had in the suit marked FHC/ABJ/CS/2341/2022 said he would need his doctors to conduct an independent examination to ascertain his actual state of health. He is praying the court for an order granting him leave to apply for judicial review in front of an order of mandamus, compelling the respondent to allow the applicant unhindered access to his medical doctors to enable them conduct an independent examination of his present deteriorating health condition as earlier ordered by the Federal High Court, Abuja, Quran. Honorable Justice B.F.M. Nyako on the 21st day of October 2021, as required by the express provision of Section 7 of the Anti-Torture Act 2017, as well as an order of this Honorable Court granting leave to the applicant to apply for judicial review in the form of an order of mandamus, compelling the respondent to avail the applicant with all his medical records from the 29th day of June 2021 till date. Kanu listed some of the records he will require from the DSS to include his admission records, medical and clinical notes, nursing notes, observation charts, and documentation during treatment or stay in hospital, laboratory test results, pharmaceutical records, radiological scans, image and reports, blood transfusion record, physiotherapy and rehabilitative treatment records, clinical finding, as well as diagnosis and treatment prescribed records. On ground upon which he filed the application, Kanu noted that trial Justice Nyako had on October 21, 2021, ordered that he should be allowed access to 3 persons of his choice, including his medical doctor. Kanu argued that Section 17 of Anti-Torture Act 2017 provided that a person arrested, detained, undergoing custodial investigation shall have the right to demand a physical and psychological examination by an independent and competent doctor of his own choice after interrogation, which shall be conducted outside the influence of police or security forces. The respondent have repeatedly denied the applicant access to medical doctors of his choice to independently examine him, contrary to the order of the court made on the 21st October 2021 and the express provision of Section 7 of the Anti-Torture Act 2017, he added. In a verifying affidavit that was deposed to by one Chimwanya Enenare, Kanu told the court that period to the time he was arrested, abducted in Kenya, and extraordinarily rendered back to Nigeria, he visited a special cardiologist every week for medical examination and treatment. Medical report containing the medical history of applicant, as was issued by medical specialists managing the applicant before his abduction in Kenya and extraordinary rendition to Nigeria, are hereby attached and variously marked as exhibits MNK3, MNK4, and MNK5. That notwithstanding the fact that the applicant has been discharged by the appellate court and his further detention prohibited, the applicant is still being held in solitary confinement in the custody of the respondent, where he is exposed to daily mental and psychological torture and degradation of his human person. Kanu alleged that upon his abduction in Kenya, he was subjected to various forms of brutal torture and inhuman treatment and degradation, all of which worsened his health condition, pursuant to which he suffered a mild cardiac arrest before he was smuggled back into Nigeria. The applicant's health condition was continued to take a downward spiral since then. that various medical personnel that attended to the applicant whilst in custody had repeatedly informed him that they could not ascertain the reason for the depletion of potassium in the applicant's blood. That on various occasions, the medical personnel brought by the respondents took the applicant blood sample and allegedly transported same to South Africa for screening, and up to the present, there is no end in sight for their trial and error Medicare. That all medical experts that have so far attended to this complex health situation of the applicant failed to medically fathom the explanation for the continued failure of various treatments so far given to the applicant. Hence, their inquiries as to whether the applicant may have been injected with a dangerous substance by those that abducted him in Kenya before being forcefully smuggled into Nigeria. That the medical personnel attending to the applicant in the custody of the respondent are oblivious of the cause of the applicant's health condition and are basically using the applicant as a guinea pig while carrying out a trial and error exercise, as they keep changing his drugs and increasing the dosage without any improvement whatsoever in his health condition. Attached and marked as Exhibit MNK 6 is a copy of the applicant's medical report issued by the respondent. That the full medical history of the applicant as contained in his medical file with the detaining authority were deliberately suppressed, as the facts of the speedy depletion in his potassium content was clearly deleted from the medical report which the respondent issued to the applicant. That the applicant's doctor, Dr. Sifine Okorochukwu, who had gone to visit him on the 29th August 2022 and 1st and 5th September 2022, respectively, was denied access to him by the respondent in flagrant disregard to the order of the trial court made on the 21st day of October 2021, which order directed that the applicant should be allowed access to 3 persons of his choice, which persons include his doctors. Attached and marked as Exhibit MNK 8 are copies of the letters forwarding the name of the doctor to the respondent. That following the continued refusal of the respondent to allow the applicant access to his medical doctor on the 12th of December 2022, the applicant, through his lead counsel, Chief Mike Ozekomesan, wrote to the respondent and demanded that the applicant be given unhindered access to his own medical doctors, and further, for the applicant's comprehensive medical record. A copy of the said letter is hereby attached and marked as Exhibit MNK 9. That the respondent roundly ignored the applicant's request to be availed of his medical records and access to his doctors. The deponent averred. It will be recalled that the Court of Appeal in Abuja had on October 13, 2022, quashed 15-count terrorism charge the federal government entered against Kanu, even as it discharged him. However, following an appeal, FG lodged before the Supreme Court, the Appellate Court on October 28, 2022, granted a stay of execution of his judgment to await decision of the Apex Court. My wonderful people, now here I go the Wusawala Senebika Wula Wusawala CDB, and here I go to pack my motor because fuel subsidy never allow us. Meanwhile, if this is your first time of joining us on this wonderful channel, please go ahead and subscribe to our channel. You don't see a CDB, will be the matter where we say consign MNK or Hamadika Ndibo, say the FG and Nigerian government, the court. They be like say that they use and play go and forth, back and play. You know, that kind of football where we say we they play that time where we say we they small. Yeah, but one thing where we say is that Abiyama they are alive for and go still answer to the prayer of Israel. God bless you for listening. Thank you.